I'm Sarah Lincoln. I work at Gesellschaft für Freiheitsrechte, GFF, Society for Civil Rights. We're a Berlin-based human rights organization, and we do strategic litigation to defend human rights in Germany and sometimes in Europe. So what I would like to do today is I'd like to explain to you what strategic litigation is and in which thematic areas we work, and I'd like to give you a few case examples to make our approach easier to understand for you. So first of all, I'd like to start by explaining a little bit our approach and what strategic litigation actually means. So organizations that do strategic litigation are trying to reach a legal, political, or societal change beyond the individual case. So normally if you take a case to court, you want to win that case, and you're not following goals that go beyond the individual case. In strategic litigation, it's a little bit different. You try and choose a case that stands for a structural problem, and you want to either set a precedent, reach a court decision, best of all of a high court. In Germany, it's mostly our goal to get to the constitutional court, and then reach a decision either on how certain laws have to be interpreted to strengthen human rights, or in many cases, we even want laws to be declared unconstitutional. In Germany, the Constitutional Court is the only court that can declare a law unconstitutional. That's why that's the court we have to aim at in these cases. And so these are the legal goals that strategic litigators pursue. So either to set a certain precedent, to get a law declared unconstitutional, and thereby creating an effect that other people can profit from. So all the people that are affected by this law or by this certain interpretation. Often strategic litigation does not only aim at legal change. So sometimes we bring cases where we already know that in court we might not succeed with this case, but we want to show that there is a problem, that there is a legal gap. We want to put pressure on the government to change something, or we want to create a public awareness for a problem. So sometimes strategic litigation goes beyond a change at the legal level and aims at political or societal change. And that's why it's a really important part of strategic litigation to do some communication around the case and to work in a collective. So in all of our cases, we work with other NGOs, with networks, with activists, with other people working on the issues involved, because often it can make sense to take a case to court, but at the same time to have the case set in a broader advocacy strategy. So sometimes other organizations will accompany the case with an advocacy campaign or with lobby work, and that makes the whole movement stronger. And then what's also important is that strategic litigation requires a careful selection of cases. So obviously, to bring a case to court and then to take it up to the Constitutional Court requires selecting a case that actually represents a structural issue that is ideal to show the problem that you want to raise, and you need claimants that are also aware that this is a case of strategic litigation, that are prepared to move through all instances, that are prepared to if ideally, be part of the communication around the case. And last but not least, it's important to be prepared for a long procedure. So taking cases up to the Constitutional Court, or even the European Court of Justice, or using human rights mechanisms when the national remedies are exhausted, can take years and years. So strategic litigation is something that needs a lot of time. So now this is all being quite abstract, and I'd like to illustrate a little bit more specifically what we actually do. I said strategic litigation for human rights. So this definition that I've given you so far could be actually used for any issue you want to. So, for example, business associations that take cases to international investment courts would probably so that's why it's important to specify what you're actually doing. And when we speak of human rights litigation, we have set 4 thematic pillars in which we as organization see our focus. And I'd like to just take you through these pillars and explain a little bit about our work in these areas, and go into some detail on some of our cases. And I think that will also nicely illustrate that there's a lot of different strategies that you can use when doing strategic litigation. So the first area we work in is enabling space for civil society. So it's basically about defending classic civil rights, the freedom of assembly, the right, freedom of speech. We have a whole project that is focused on defending whistleblowing, and another big project which focuses on defending non-profit political activity. I'd just like to say a few sentences what I mean by defending non-profit political activity. Some of you might have gathered it's a problem that doesn't only exist in Germany, but in the last few years in Germany, associations in Germany, there is a status, it's a non-profit status that you can have as an association engaged in education or also politically engaged. But in the last few years, many of these organizations have lost this status because basically administration says that they have been politically too outspoken, and that this is a problem for their status. Now you would think, okay, what do you need this non-profit status and public interest status for? Actually, it's very important because it's a prerequisite to be able to use public spaces that are provided for non-profit organizations. It's a requisite, or it makes it easier to receive donations. It's requisite for receiving funding from foundations, but also from the state. So when the state starts telling a whole lot of NGOs, community centers, and other politically engaged people that their association loses this status, this actually means that some of them really have to pack up and cannot have real financial problems. That's why we have one of our focuses here. We are currently supporting several cases of organizations that are affected by this new practice in Germany. So, for example, a community center in South Germany that is people work there on a voluntary basis and do like cultural events, music events, but also some political events. So, for example, on climate change or on the negative effects of capitalism. And these events, especially these political events, led to them losing their status, and now they are in danger of having to shut. And in our opinion, this is a very dangerous development, because it means, or for democracy, you need politically engaged people, and you need spaces where people can politically engage. And it's a problem if the state uses certain laws, even if they may seem harmless on first sight, to limit these organizations financially. So that's one of our focuses in this area. The second focus area of GFF, and I think that's the area that GFF is most known for, is data and surveillance. So in this area, we go to court against excessive surveillance laws, but also practices by police and intelligence services, and want to submit them to better constitutional control. And so one of our most recent cases that was also quite a bit in the media is a successful constitutional complaint against the Federal Intelligence Service law. What's quite interesting, that's not, wait a second, here it is. So what's quite interesting about this case is that we could go straight to the Constitutional Court. At the beginning I said we often aim at the Constitutional Court because it's the only court that can actually overthrow a law. Say this law is unconstitutional, it violates constitutional rights, and actually overthrow the law. And in this case, we didn't have to go through the instances to then end at the Constitutional Court, but we could go directly to the Constitutional Court. The reason for this is that when laws that allow, for example, the intelligence service to survey people, it's very difficult. People who are affected don't know that they're being surveyed, so they can't take their individual case of surveillance to the lower instances. So that's basically an exception where you can then, as affected person, go straight to the Constitutional Court and get them to revise the law. And that's what we did together with Reporters Without Borders, and our claimants were mostly journalists working abroad. And what one of the main questions we took to the Constitutional Court was the question whether the Federal Intelligence Service is bound by the Constitution even when they're acting abroad, because the law that their work is based on, the Federal Intelligence Service law, at the moment is based on the assumption that the intelligence service is not bound by the constitutional rights when it surveys foreigners in other countries. So as you know, intelligence services work that way. They're surveying people all over the world. And so far, the German intelligence service did that without being bound by the German constitution, or at least that was the assumption that the law was based on. And that was one of the central questions we wanted to have clarified by the Constitutional Court. And this case was a big success because, among other, the Federal Constitutional Court made clear that German state authorities, so intelligence service, but also other authorities, are always bound by the Constitution and by constitutional rights at all times, in all locations, and regardless of whether the target is a German or a foreign national. So if they are surveying journalists abroad, foreign journalists, they still have to respect the rights to privacy from the German constitution. And the decision of the Constitutional Court had a few other quite important aspects. For example, so far the intelligence service in Germany was not submitted to any sort of independent control mechanism, or at least the control mechanism was identified as very deficient, so that has to be completely reformed. So this was a big success, and I think it's a good example for strategic litigation, where you can see that some of the statements made by the Constitutional Court even go way beyond the work of the Federal Intelligence Service. For example, the statement that our constitution binds German authorities wherever they are acting. Another interesting case that I would like to go into a little bit more detail on is our case on refugee phone searches. So in Germany, there is a law that says that if refugees are unable to present a valid passport when they arrive in Germany, the Migration Office routinely examines data from their mobile phones in order to verify their identity. And so basically what we started with when we decided that this seems to be quite a grave violation of their privacy, analyzing their phone and the data, but there was not much known about what was actually happening there. So first of all, GFF published a comprehensive study on this approach in December last year. We worked together with a journalist and researched what data is actually analyzed and what results this brings. And this study shows that what happens is that the Migration Office uses a software and checks country codes, languages, in text messages, location data, domain endings, browser history, geodata from photos or emails, and tries to, from this data, gives probabilities for the country of origin. And actually, the study shows that this whole procedure costs a lot of money, the software, but also the work involved in the individual analysis, but doesn't bring very reliable results, because refugees cross a large number of countries on their way to Germany. Often they lose phones or change phones, or don't have the same phone that they had when they left the country. So actually it's not only a grave violation of their privacy, but also quite a useless instrument. And so based on the research in our study, together with 3 asylum seekers affected by this practice, we have filed 3 court cases against this practice and the underlying law. And in this case, we will have to, so this goes to the administrative court, and then we will have to move through 3 instances up to the Constitutional Court to have the law revised and declared unconstitutional. And yeah, as I already said, our argument in this case is that mobile phones are a very private matter, especially for refugees, because due to their separation from home, family and friends, they play a central role in the lives of refugees. And in our view, the search and inspection is a serious violation of their privacy, especially considering that it doesn't bring viable results. And so I think this citation from one of our plaintiffs really shows what an impact it can have. So he said, suddenly the BAMF, that's the German immigration office, the BAMF employee told me to hand over my mobile phone and unlock it. I didn't really know what was happening. Nothing was explained to me, but I was afraid of being deported, so I gave him the mobile phone. It felt like I was handing over my whole life. And I think that describes quite well what a serious violation of privacy this is. So these cases are pending and will probably take a few years to actually reach the Constitutional Court and get a decision on the constitutionality or unconstitutionality of the underlying law. But yeah, I think these cases are very important because it needs organizations like GFF or others to take these cases to court, because for the refugees affected, this is obviously a violation of their privacy, but they have other worries that are more important to them. They are worried about their asylum procedure and their existence and whether they can stay in Germany or not. And so that's why I think, especially in the area of migration law, the state at the moment, at least in Germany, is passing quite a number of laws that are, it's pretty obvious that they're unconstitutional, but they just don't expect anybody to actually go to court against these laws. And that's why it's important that human rights organizations like GFF actually take these cases to court and get these laws revised. And another case I'd like to tell you about, because it's a little bit of a different approach, is our criminal complaint against illegal export of spyware. So in summer 2019, GFF, again together with Reporters Without Borders and 2 other organizations, Netzpolitik.org and European Center for Constitutional and Human Rights, jointly filed a criminal complaint against a company, a German company called Finn Fischer, which produces spyware and exports this. So our criminal complaint is based on the suspicion that Finn Fischer exported spyware to Turkey without the required export license. So basically, the export of spyware before 2015 was not regulated, and then organized NGOs and journalists found out that European-produced spyware was excessively used in the Arabic Spring by governments to repress opposition protest journalists. And there was quite an outcry that basically European companies are producing spyware for authoritarian and repressive governments. So in 2015, the EU regulated the export of spyware. So since January 2015, if companies want to export spyware outside of Europe, they need a license. I keep speaking of spyware, so I was just thinking maybe not all of you know what that actually is. So basically, it's software that governments, so intelligence services and police can use to infiltrate mobile phones or laptops, and it actually gives them complete control over a telephone or a laptop. So they hack themselves into the phone and can then read all the chats, listen to all the conversations, follow all the movements, take out all the data, etc., etc. So it's very, very, very invasive. And even in democratic states, it's a massive violation of privacy. But in repressive states, where it is basically used to spy on anybody with a different opinion, it can have very, very dramatic consequences, because people, it is used to arrest people for basically nothing. And that is basically what happened, or what we assume happened in Turkey. So, as I was saying, since 2015, the export has been regulated, and in summer 2017, FinSpy, that's the spyware produced by Germany, it's this Munich-based company FinFisher, was found on a fake website, which was targeted at the Turkish opposition. So this is the website that you can see here in this little picture. It pretended to be a website which was part of a protest movement in summer 2017 under the motto Adalet. And you could then download this application that was pretending to be like a sort of networking application. And you might remember that after 2016, Turkey has become more and more repressive. So in 2017, thousands of people had been arrested, many journalists also. So you can imagine that was not really the hands where you would want such intrusive spyware. And so in our criminal complaint, we argue that, okay, this FinSpy sample was found in Turkey, and we have statements of the government saying that they have not given any export license to any company since 2015. So it makes it quite likely that the export of FinSpy was without the required license. And the main part of this criminal complaint, that's maybe also quite interesting, is actually not legal argument, but a technical analysis, because obviously the software found didn't have FinSpy written all over it, but there was quite an extensive technical analysis by IT experts showing that this was definitely FinSpy because of all the similarities to other FinSpy samples that had been leaked or found previously. And what the technical analysis also showed is that the software was produced after 2015, so after this export regulation was introduced. And this criminal complaint has also been quite successful. So there's not been a conviction yet, but last month the public prosecutor in Munich searched 15 objects of FinFisher and partner firms in Munich, so offices, but also private apartments. And this search went 3 days and was quite a big thing, and is definitely a result of this criminal complaint, and shows that the public prosecution is taking this quite seriously, and shares our suspicion that there might have been an illegal export to Turkey and to other countries, because Turkey is not the only country that FinSpy has been found since 2015. So, just to remind you, GFF, I said, works in 4 different areas. So I've talked a little bit about enabling space for a civil society, about data and surveillance, and I'd also like to speak a little bit about the last 2 pillars, which are equal rights and social rights. So in the area of equal rights, we have quite a few anti-discrimination cases. So in this area, our work is about taking action against discriminatory laws, authorities, but also companies. And one of our most well-known cases is a case where we're supporting a woman, a journalist, who found out that she earns a lot less than her male colleagues. And this case is quite interesting because there's clear European law on equal pay. And in many other European countries, there has been much more development in that area, whereas in Germany, the pay gap is still very large. Even if you take away all aspects like women working in certain areas, like doing more social work than men where you earn less, or interrupting work for family, etc. Even if you take all these aspects away, in Germany there's still a difference of 6% in wages between men and women. And the courts so far show no willingness to make it very easy for women to claim equal pay. And this is one of our cases where which shows that you need a lot of patience for strategic litigation. So we have gone through all the instances. At the moment, we have the case pending at the Constitutional Court, and all of the lower instances have completely ignored European law on equal pay. So one of the main aspects of this case is that the European Court has long-standing decisions saying if a woman can prove that at least one man earns more money for the same work, then it is up to the employer to explain why this is the case. So you have an inversion of the burden of proof. The woman has to prove less money for same work, then the employer has to explain why and justify this. This makes total sense because it would be very difficult for the woman to explain that this is due to her sex. So different in German courts. In German courts, in our case, we managed to show that this journalist earns less money than many of her male colleagues, all of her male colleagues, for the same work. Often her colleagues even had less experience than her, and still the German court, both German courts said that she has to show not only that she earns less money, but also that this is a discrimination based on sex. So she was expected to prove that she was being paid less because she was a woman, and we still haven't found out what exactly the courts were expecting. So were they expecting her to have some written statement from the employer saying that he generally pays women less, or how exactly she was supposed to prove this, other than by the fact that all men earned more than her, is still not quite clear. And yeah, we hope that we can still win this case before the Constitutional Court, and if not, then strategic litigation can also mean that we have to take the next case on equal pay until there's a change in German jurisdiction in this area. So it's not always enough to bring one case. You have to really keep to an issue and bring another case, and sometimes it can take years and years and years for the mindset to change and for the to build up the pressure also in society, on politics, to bring about a change. Then the last area we work in is social rights. So all people have the right to adequate housing, to social security, and to healthcare, regardless of their income, origin, and status. And that's something we want to enforce in court, and that's an area that, in our opinion, is equally important to civil rights, because it's if you don't have adequate housing or adequate healthcare, then you don't really have the energy left to go out on the street and use your freedom of assembly or your freedom of speech, because you're basically struggling to survive. So I think that's an area that should not be neglected, and social rights and civil rights belong together and yeah, are both equally important. And I'd like to speak about one of our cases in this area, because it is a little bit of a different approach. But yeah, before I do that, maybe to give you an overview, in this area we have one focus on health. So we're looking into access to health for undocumented migrants in Germany, and overall access to health for refugees. And then another area we work in is on housing. So in Berlin, for example, there is a new law limiting the rental prices, and there's a lot of conflict about this law. So I don't know, some of you might know that in Berlin the rental prices have risen dramatically, and a lot of people cannot afford their flats anymore, or cannot find affordable flats to rent. Meaning that families in Berlin are living in much too small flats because they can't afford a larger flat. And so the government in Berlin decided to limit rental prices for a phase of 5 years. And we looked into the constitutionality of that, also considering international human rights on adequate housing, and handed in an amicus curiae brief. That's something that comes more from the American law tradition. So basically it's the possibility, amicus curiae means friend of the court. So the law that was passed by the government is at the moment pending at the Constitutional Court. As I said at the beginning, not only human rights organizations do strategic litigation, but also the landlord associations did their bit of strategic litigation. So there are about 7 complaints pending at the Constitutional Court against these price limitations for rental apartments in Berlin, and we have handed in a statement on the constitutionality of this law that we believe is proportionate and constitutional, especially considering the state obligations to provide adequate housing. So the case I wanted to look into in a little bit more detail is our case on social welfare for asylum seekers. So asylum seekers in Germany only receive a minimum amount of social welfare, and so less than the social welfare for people who live here permanently. And in September 2019, the government reduced the welfare for asylum seekers living in collective accommodation by another 10%. The reason for this is slightly absurd. So basically, the Parliament said that they believe that asylum seekers living in collective accommodation have possibilities to save money because they can cook together and buy things together, share things, and so that would reduce their costs by approximately 10%. So what's so absurd about this is that basically people live there that don't share the same language or background or culture. Often they don't live there for the same amount of time, they don't know each other, and it's completely unrealistic that they would live there together like a big family, shopping and cooking together. It's just not what's happening in these accommodations. So already quite a few courts have made it clear that they think that this cut by 10% is unconstitutional, because in the German constitution gives everyone the right to decent minimum subsistence. So that's a constitutional right that is violated if the government reduces this welfare without providing a reason or reasonable arguments for this. So as many courts have, because many courts have already said they think this is unconstitutional, our idea, or we tried a little bit of a more innovative approach to this case. So we decided that, okay, the fastest way to get to the Constitutional Court, because as I said earlier, it can take a long time to go through all the instances, and it's only the Constitutional Court that can declare a law unconstitutional. But there's a second way to get to the Constitutional Court, and that's if a lower court says that the law that it would have to apply to decide a case is unconstitutional. It can't just decide, okay, I'm not going to apply the law, but it has to submit the case to the Constitutional Court. So it basically pauses the case and says, wait, I can't decide this. I think the law I would have to apply to be able to decide this it violates constitutional rights. So I'm going to have to call on the Constitutional Court to decide. And so it submits the case to the Constitutional Court. That's a much more direct way to get to the Constitutional Court. But not many courts use this option because it's a lot of work. You have to there are very, very high requirements of how detailed you have to argue the unconstitutionality, and you also have to argue that there was no other way you could decide this case without, by interpreting the law differently, for example. So not many judges are really prepared to use this. And so our idea was that we would prepare a full submission on the unconstitutionality of the law and basically provide this submission for judges to use. So that is what we did, and we published this full submission in September of this year. And I think this strategy has already been quite successful. So we are in conversation with a few judges, and will probably, there will probably be a submission on this law based on our draft submission. So I just wanted to present this case to you as a different approach to strategic litigation, because what strategic litigation is also about being creative and finding different ideas that actually fit to the case. So yeah, that's. I think I stop here. I've given you a little bit of an overview over some of our cases. I've shown that sometimes you can go straight to the Constitutional Court. In many cases, you have to go all the way through the instances. In this last case, we chose a completely different avenue. And as I said at the beginning, often, yeah, even if you lose a case, you can use this case to show that there is a gap or that maybe politics the government has to become active and change a law because there is a gap in access to justice on certain matters. So, for example, in our equal pay case, there has been a lot of media attention, and we can use the case to uphold the pressure on the government to improve equal pay in Germany. So yeah, that's maybe as an overview of the different cases, and yeah, I'd be happy to answer questions you have on our work.
Perfect. You should be able to hear me again now. Thank you so much for the presentation. We have a ton of questions, so if you have some time, we'd be very happy to have you answer them. It's going to take just a second to share the screen. Here we go. Okay, so the first question that we got was, you said that you often choose cases that stand for, wait, I can't read it. What did I say? For cultural, thank you. For cultural problems, where do you currently see a big demand or a big gap in Germany?
Yeah, I think there are a great many areas where we have structural human rights problems in Germany. So, as I was saying, the whole asylum and migration law is an area where the government is passing laws that are quite obviously unconstitutional, but they can do it because they don't expect anybody to actually take these cases through the instances into the Constitutional Court. And even if people do, as I say, it takes years and years. So at least the unconstitutional practice just goes on for a few years before it is stopped. Another area, I think, is the whole area of surveillance. So that is something where yeah, police and intelligence services are just getting more and more surveillance powers. So every year in Germany, a law is reformed that gives police and intelligence services new possibilities to survey people. So now, for example, police and intelligence services can use spyware, like I was talking about spyware earlier, to infiltrate phones and laptops of people that they are surveying. So that's an area where a lot of a lot of law reforms are happening, and where organizations are needed that counterbalance this. So yeah.
Yeah, and I mean, especially considering what you spoke about regarding surveillance, and then thinking about the entire topic of artificial intelligence and how that might cause more inequalities, which is all topics we've touched on within the last 23 hours. Definitely a really, really relevant thing to discuss. I see now that tech support already chose the question that I was going to pull up next, because this is something that you just mentioned. One of our viewers asked, how can it be that it takes up to 3 years for an unconstitutional law to be declared unconstitutional? And do you think that the instances of appeal should be reformed in Germany?
Yes, actually, it takes much longer than 3 years. A case can even be pending at the Constitutional Court for 3 years before it's decided. And before it gets there, it has to go through all the instances. So especially in administrative law, sometimes just the first instance can take 3 years. And then the appeal instance, another 3 years. It can take 12, 13, 14 years to get to the Constitutional Court. And I absolutely think that this has to change, and that this is not an effective access to justice for affected people.
Especially the point that you just mentioned, access to justice, keeping a court ongoing, or more to the point, keeping an appeal ongoing for many, many years obviously isn't cheap either. So definitely see a huge gap, unfortunately, within access to justice in Germany at the moment. Then maybe a question that kind of continues on with the train of thought we're having right now. Somebody asked what the longest case that you've worked on has been, and if it went up to the ECJ.
Yeah. So actually, so our organization was only founded in 2015. So a large number of our cases have already been going on for 5 years. But I'm sure that if you ask me again in 10 years, I'll probably say, yeah, our longest case has been going on for 15 years. So yeah, many of the cases can take a long time. And we have a case pending at the European Court of Justice. So that's a case which is about passenger data, because there's a new law that flight passenger data is collected. So it's a counter-terrorist law. And so data on all passengers is collected and can be used quite excessively. And so we took this to various courts in Germany and managed to get them to submit the case to the European Court of Justice, where it is now pending.
So do you have any hopes as to how long it's going to be pending, or
actually that's not quite such a big problem at the European Court of Justice. Apparently the average time is about 1.5 years, so that's a bit better.
Okay, that's surprisingly, that's quite nice to hear, with some knowledge in the back of my mind about the European Court of Human Rights and how many cases they currently have.
Oh yeah, that takes much time. Yeah, European Court of Human Rights. Wow, that's
yeah, quite overworked.
Yes.
But good that there's people fighting for human rights and causing this amount of overwork. Okay, so next question. Somebody asked, when you talked about the refugee phone search, I had to think of European lawyers in Lesbos. Do you work and collaborate with other organizations sometimes?
Yes, absolutely. So on our migration-related cases, we collaborate with organizations specialized in the area of refugee and migration law. And in cases that have more of a European dimension, where we would also collaborate with other European organizations. So we always try and work in networks.
Okay, that's probably really interesting to hear for our viewers as well, because we, as European Law Students Association, have associations spread over 44 different countries. So obviously, not everyone is going to end up working at the German Civil Rights Society, but the opportunity of collaborating over different countries within Europe, for example, to help and appeal decisions which people believe to be unconstitutional is definitely a very interesting and very exciting way that you can go within your career once you've studied law. So for any international and non-German European viewers, definitely some good information. So someone else commented, your work is really inspiring to me. Could you maybe talk a little bit about the journey that brought you to GFF, so to the Gesellschaft für Freiheitsrechte? How can a law student later work in this field?
I think my personal journey was I was already quite politically engaged as law student. So in Germany, there's you can engage in law student groups. And I was always interested in migration law, human rights law. So after university, I did quite a few internships in related organizations, and then started working as human rights policy advisor at Bread for the World. That's a big German charity, which also has quite a big political department and also does human rights work. And that was a little bit more international work. So I did quite a lot of work at the United Nations. And from there, I moved to GFF. So that was basically my journey to GFF. And I think what I can advise anybody who would like to work in the NGO area is to try and get internships, to get to know people, to be in groups and networks, because in the end, I think it's not that difficult. If you're interested and engaged in the area, we're always looking for good and engaged people to support us, and GFF is also growing. So yeah.
Nice, thank you very much. And I feel like the conversation and the back and forth is actually always a really good segue into the next question, because you just mentioned political, and obviously, like, as a law student, being involved in politics and maybe more political associations as well. So we got one question that reads, sometimes authorities argue that associations are too political, in brackets, and then they can lose their non-profit status. So the question is, what would you respond to, I assume they mean to associations being too political?
Yeah, I think it's a really difficult discussion, because I believe that a lively democracy needs the possibility for people to engage in associations where they can take a stand. Because to take the example of the community center I was speaking of earlier, I don't think people want to spend their free time voluntarily engaging somewhere where they cannot say their opinion, and where they cannot say organize a debate on the negative effects of capitalism. Or I think one of the debates was also what is anarchy. That was one of the things in the letter of the administration where I said, okay, this is too much. I mean, this is just not public interest anymore. But I think what they didn't really consider is that it's not about agreeing with these political positions. It's about creating the space for people to think about things, to get interested in politics, because that's what democracy lives off of. And it's also because this center is something where a lot of young people are also engaged. So I think my response to something being too political is, so what? We need, on the right and on the left, the possibility to say your opinion and a lively debate. And if the state closes down these spaces, then what is left? Because, I mean, where do young people go if they want to debate something, if there's no community centers and youth clubs left because they've been closed because of being too political? So I think that's something that a democracy has to be able to tolerate. That's an important part of debate and society, and
yeah. So that's actually been a huge discussion, I'll say, within the European Law Students Association and the international network within the past few years, just considering how many different jurisdictions and societal ways and forms, but also how many different cultures we have covered by the broad span of the network that we're in. And that's obviously incredibly enriching and great to have this amount of cultural exchange and these opportunities to talk to people who've grown up completely different and they're still studying law just in a different system, and having that platform. But then obviously having this balance act of trying to say, so also on an international level is non-political, and on a German level we're party politically neutral, so based around the entire assumption that when you're standing up for human rights, it's impossible to be non-political because you need politics to defend human rights. But just going off on the assumption that you don't need to belong to a party and you don't need to endorse a party to stand up for human rights. And that's just been an incredibly interesting discussion the past few years, hearing input from obviously people who maybe next to their law studies have been very politically engaged or haven't done anything with politics so far, and maybe they're just, I don't know, volunteering and working for ELSA at some point, some local or national group in a different country. But it's always a very interesting discussion to have, because obviously considering the entire aspect of being an engaging society and being an individual that is engaged within society and trying to make a change for the better, sometimes you do have to be political, even if it's not very close to a party, to actually be able to accomplish what you're trying to. So
yeah, absolutely. And just to clarify, I mean, when I'm speaking of political, I mean, of course, an association has to be like neutral in terms of not belonging or supporting a certain political party. I think it's absolutely legitimate for the state to say, okay, I mean, if you're like basically the right hand of a certain political party, you cannot be a public interest association. But I think if you want to defend human rights, as you say, that is not neutral work. That is always political work. And you need to take a stand for something against discrimination, for marginalized people, or against state surveillance. It's always a political discussion.
Yeah. Okay, so I will go back over to the questions, and we have one more which asks, do you see an advantage? So I believe this is referring to something you said earlier in the presentation. Do you see an advantage in sometimes having to go through all instances versus going straight to the Federal Constitutional Court?
Yeah, well, of course, the advantage is that you can also win in the lower instances. Sometimes you don't have to go right to the Constitutional Court. However, if you want, if it's about the underlying law, then yeah, you have to go up to the Constitutional Court, and I don't really see a lot of advantage for us, but I do understand why you can't just take your case straight to the Constitutional Court, because obviously that would be a complete overburdening of the Constitutional Court. Obviously, you need to give the lower instances a chance to see if there's another solution, or if they can solve your problem. So and maybe an advantage can be that sometimes you there are things that you can consider that maybe you didn't see, and that in the lower instances you suddenly, the lower court gives you a different idea, something that you'd maybe missed, and that you can then take up for the further procedure.
Okay, I think that's definitely something I wouldn't have thought of, but obviously you can get inspiration in many different places, and if it happens to happen while you're on the way up through all of the instances, you can always see that as an advantage, and it is always nice to get something positive out of a situation.
Yeah, and I mean, strategic litigation is very difficult to plan. So what can also happen is that your claimant, something changes in the whole situation, and then you basically don't have a case anymore. So that's also something you have to consider when you go through the instances. Or even if your claimant knew that it was going to be a long procedure, it's always up to the claimant whether they want to take the case further or not. So that's also something that can be quite a challenge with these year-long procedures.
So has this happened to you, that you were in the middle of a case and you were on the way up through the instances and suddenly the claimant decided not to want to continue, or something changed and you couldn't continue with the case anymore?
Yes. So we had a case. It was about, there was basically a town in Germany had created like a group it was basically a group of state representatives and town representatives on integration. And it was also, there were two migrants participating in this group, and then the town changed the law and said only migrants with a permanent status, so a permanent status in Germany, could participate in this group that was basically on how to better integrate people in Germany. And so these two people participating were basically pushed out of this group on the basis of this new law. And we decided to take the case to court with them because we just found it completely ridiculous that they'd been living in Germany for 10 years. I mean, it was that they had a very insecure status. And they were quite convinced, and then we lost in first instance. And one of our claimants was just so shocked. I mean, he hadn't anticipated this, but he was really disappointed. And it really got to him that the court had that we'd lost this case, that he said it was just too much for him to carry on. So he decided to opt out, and we actually found a new claimant who was prepared to work in this group and couldn't based on this law. So it was okay in this case, but that's something you have to consider. That can always happen, and even if it's strategic litigation and we want to reach something beyond the individual case, the claimant and the claimant's interest always has to go first, and that is something that has to be respected, and that's just tough luck then, and that's, we have to deal with it.
That's an incredibly perfect segue to the last question that we got from an audience member, though, because somebody asked if it's possible in Germany to take independent legal action against human rights violations as an association on behalf of human rights, or if you always need a plaintiff to be able to do that, or a claimant.
In Germany, this possibility is much more limited than in other countries, unfortunately. There are certain thematic areas where you can, you don't need a plaintiff, but can go to court as an association. So that's, for example, in the area of consumer rights. So there's a consumer rights association in Germany that can bring violations of consumer rights to court. There's also this possibility in the area of environmental rights. Restricted, but yes, in certain areas, environmental organizations can bring claims on behalf of the environment. And then now it's new. In Berlin, there's a new anti-discrimination law, and you can register as an association working on anti-discrimination, and then bring anti-discrimination cases as an association. And we have now, we are currently registering as such an association, and will then hopefully be able to bring cases without needing a plaintiff, and that's especially important in anti-discrimination cases. So I was telling you about our equal pay case that so far we have lost, and our claimant, the journalist, it's been terrible for her. She's been basically mobbed out of her job by her employer for taking this case on equal pay to court. And I think that's quite a typical scenario in anti-discrimination cases, because you expose yourself, and you put yourself out there, say, you take a case, and then basically you make yourself very vulnerable as a claimant. So that's why I think there aren't that many cases on discrimination in German courts.
Mm. And I think what you just mentioned, unfortunately, you can see that in many different areas, because it's obviously not only this huge aspect of being completely vulnerable and potentially having, if it's, for example, an anti-discrimination case at your work, this entire environment that might potentially turn hostile as you are, well, taking court action against them for unconstitutional behavior, might as well be said. But aspects we mentioned earlier on too, that if the trial ends up not happening, but if the trial ends up taking many years, it's obviously a financial situation in question as well. And I'm sure, I don't know anyone that I could cite right now, but I'm sure there's probably a study somewhere that also talks about how much of a mental pressure it must be to have such a huge case and such a huge part of your life ongoing for years and years. And depending on how big of a case it is, obviously it might be in the public eye for quite some time as well, which I'm sure could have quite the negative harm and quite the negative impact on someone that's attempting to stand up for their constitutional rights. So the possibility in Berlin to now register as an association and then potentially be able to take up these cases by yourself as an association without needing a face or the face of a claimant or a plaintiff in front of you is, from what it sounds like to me right now, a really, really big step in the right direction regarding equal access to justice. Have you heard of maybe different countries in Europe that already have this? Like, is this a concept that's quite large in different countries, or is it something that's newly being discovered and potentially only implemented in very minor cases in small places?
So I don't know the details in every European country, but what I do know is that it's much more established in other European countries that you can take cases as an association. So in UK, I know that it's quite is possible in many areas, but I think in other countries as well. And I think it's quite unique in Germany that Germany is very cautious. They don't want like a law system where you have like collective claims and lots of associations bringing like public interest. It's basically public interest litigation is something that doesn't really, that German government doesn't really sound like the sound of, so they're quite cautious in introducing these possibilities. But as you say, there are some good developments like in Berlin, or on environmental issues. I mean, it's obvious because who's the claimant when the environment is harmed? So yeah.
Okay, perfect. Then thank you so much. I've just checked, there's no further questions in the chat right now, and I think I've definitely asked all of my questions in between every now and then too. So all that's left from our side is to thank you so much for taking part in the event, and for being the last slot that was filled, and for being here for the last for the last 1 hour, and now we have half an hour left, about 24 hours for Human Rights live stream. It's been an absolute pleasure having you and talking to you. And I think there's definitely been a lot for people from many different countries to think about. And as one of the viewers said, to be inspired by hearing about your work and about what you do. So it's been an absolute pleasure. Thank you.
You're welcome. And respect for this whole 24-hour thing. I mean, it's amazing.
It's definitely taken some coffee, but
yeah, I can imagine. You still seem quite fit, though.
Huh?
You still seem quite fit.
It's the coffee and concealer, and we have very good lights in the office. But thank you very much. No, but I mean, it's the same as with the cases you're talking about. It's nothing that one person can do by themselves. There's a huge team behind everything we do, and a huge association, and a huge network of so many people involved. And for the last 24 hours, you've been a part of the network and a part of filling the 24 hours. So it's been good to have you.
Yeah, it was fun being here, and thanks for all the really good questions. So, yeah, thanks a lot, everybody.
Nice. Then have a nice afternoon, and I'm sure you'll be hearing from Elsa the one or other time in the future again.
Bye.
Bye.